Summary of Part 1 of Kenya's Capital Markets Act, Cap. 485A. 1. Introduction and Purpose. The Capital Markets Act establishes the Capital Markets Authority, CMA, to regulate and develop Kenya's capital markets. Its core objectives are to ensure orderly, fair, and efficient markets for securities, stocks, bonds, derivatives, etc. Investor protection through rules against fraud, insider trading, and market manipulation. Transparency in trading and financial disclosures. Promotion of innovation in financial products. For example, derivatives, real estate trusts, Islamic finance instruments. The Act has been amended multiple times, most recently in 2023, to adapt to evolving markets, anti-money laundering laws, and technological changes. 2. Key definitions. Part 1 clarifies terms critical to understanding the Act's scope, regulatory bodies, and market infrastructure. Authority, CMA, the regulatory body overseeing capital markets. Securities exchange, a licensed marketplace, for example, Nairobi Securities Exchange for buying or selling securities. Derivatives exchange, a platform for trading standardized derivatives, for example, futures, options. Self-regulatory organization, SRO, entities like stockbrokers associations that enforce industry rules under CMA oversight. Market participants, dealer or stockbroker, licensed professionals who trade securities on behalf of investors. Investment advisor, a person or business providing investment advice for a fee, excludes banks, lawyers, or journalists giving incidental advice. Fund manager, manages large portfolios or collective investment schemes, for example, mutual funds. Promoter, organizes collective investment schemes, for example, unit trusts. Sophisticated investor, high net worth individuals or institutions, for example, banks, pension funds, eligible for complex investments. Financial instruments. Securities, broadly includes shares, bonds, government debt, derivatives, futures, options. Units in collective investment schemes, mutual funds, real estate trusts. Asset-backed securities, for example, mortgages packaged as tradable instruments. Excludes private company shares, bills of exchange, and certificates of deposit. Collective investment scheme, SIS. Pooled funds, for example, mutual funds, unit trusts, real estate investment trusts. Excludes retirement funds, insurance contracts, and cooperative societies. Commodity contracts, agreements to trade physical goods, for example, agricultural products or financial instruments linked to commodities. Exchange-traded derivatives, standardized contracts, for example, futures, options, traded on licensed exchanges. Key concepts. Insider, a person with access to non-public information that could affect security prices, for example, company directors, major shareholders. Beneficial owner, the real person controlling a legal entity to prevent hidden ownership. Associate, broadly includes family members, business partners, or companies linked to an individual or entity to track conflicts of interest. Interest in securities, covers direct ownership, joint holdings, options, or indirect control, for example, through a company. 3. Key rules and mechanisms. Investor protection. Investor compensation fund, established to reimburse investors if licensed firms, for example, brokers, fail due to fraud or insolvency. Prohibited practices, insider trading, market manipulation, and false disclosures are illegal. Market structure. Licensing requirements. Dealers, brokers, investment advisors, and exchanges must obtain CMA licenses. Regulated activities includes underwriting, trading, fund management, and issuing investment advice. Clearing and settlement. Rules ensure secure and transparent transaction processing. Disclosure and transparency. Information memorandum. Documents like prospectuses must provide accurate details for public offerings. Public offerings. Companies must disclose financials, risks, and ownership structures when raising capital. Anti-money laundering, AML. Beneficial ownership disclosure, prevents anonymity in investments. Reporting obligations. Licensed entities must report suspicious transactions to combat terrorism financing and fraud. 4. Exclusions and exceptions. Excluded instruments, bills of exchange, promissory notes, unless asset-backed, and private company shares are not classified as securities. Exempt entities, banks, insurance companies, and cooperatives are regulated under separate laws but must comply with CMA rules when participating in capital markets. 5. Amendments and updates. The Act has been revised over 20 times since 1989 to align with global standards, for example, AML laws in 2023. Introduce new products, for example, derivatives, Islamic finance. Strengthen governance, for example, defining roles of fund managers, trustees. Why this matters. Part 1 lays the foundation for Kenya's capital markets by 1. Defining roles for regulators, investors, and intermediaries. 2. Ensuring fair play through transparency and accountability. 3. Protecting small investors while enabling sophisticated participants to access complex instruments. 4. Adapting to technological and financial innovations, for example, online trading, commodity derivatives. This framework aims to build public trust, attract investment, and drive economic growth through well-regulated financial markets. Summary of Part 2 of Kenya's Capital Markets Act, Cap. 485A. The Capital Markets Authority, CMA. Structure, powers, and functions. 1. Establishment and governance of the CMA. Legal status. The CMA is a statutory body with perpetual succession, enabling it to own property, enter contracts, and sue or be sued in its name. Governed by a board comprising a chairperson appointed by the president, 6 members with expertise in finance, law, economics, banking, or insurance, appointed by the cabinet secretary. Ex officio members, principal secretary, National Treasury, central bank governor, attorney general, and the CMA's chief executive. Terms: chairperson and members serve 3-year terms, renewable once. Members can be removed for misconduct, bankruptcy, prolonged absence, or criminal convictions. Meetings and decision-making. Frequency: at least 6 meetings annually with no more than 2 months between sessions. Quorum: 6 members including the CEO. Decisions by majority vote. The chairperson has a casting vote. Conflict of interest: members must disclose conflicts and may be excluded from related decisions. Chief Executive. Appointed by the Cabinet Secretary for a 4-year term, maximum 2 terms. Requires 10+ years of senior management experience in finance, law, or capital markets. 2. Key functions and powers of the CMA. Regulatory oversight. Licensing. Approves and regulates brokers, dealers, exchanges, investment advisors, fund managers, and credit rating agencies. Market development. Promotes e-commerce in trading, nationwide market access, and long-term investments. Investor protection. Operates the Investor Compensation Fund to reimburse losses from broker or dealer defaults. Investigates fraud, insider trading, and misconduct. Imposes sanctions, fines, restitution orders, public censure, license suspension, or delisting of securities. Anti-money laundering, AML. Supervises reporting institutions, conducts inspections, and enforces compliance with AML laws. Vets key personnel, for example, directors, shareholders of financial institutions. Investigations and enforcement. Search warrants. Authorized officers can enter premises, seize documents, and freeze assets. Interim measures. Suspend activities or freeze assets for up to 3 months to prevent investor harm. Cross-border cooperation. Shares information with foreign regulators to combat financial crimes, subject to reciprocity and public interest. 3. Financial provisions. General fund, funded by fees, fines, and government-approved sources, covers operational costs. Investor compensation fund, sources, contributions from licensed entities, fines, recovered assets, and interest. Compensation, covers losses from broker or dealer failures. Whistleblower rewards, up to 3% of recovered sums, max 5 million Kenya shillings for valid tips. 4. Self-regulatory organizations, SRO. Recognition. SRO, for example, stockbrokers associations must apply to the CMA demonstrating sound governance, financial capacity, and fit and proper leadership. Rules and discipline. SRO's draft rules, CMA approved, for member conduct, dispute resolution, and data protection. Can discipline members, for example, fines, suspensions, but must report actions to the CMA. CMA oversight. The CMA can amend SRO rules, remove unfit officers, or override decisions. SROs submit annual reports and audited financial statements. 5. Transparency and accountability. Public consultation. Regulations and guidelines require 30-day public feedback via newspapers and electronic media. Data protection. Complies with Kenya's Data Protection Act, CAP, 411C when handling personal data. Audits and reporting. The CMA and SROs must maintain proper accounts and submit annual reports. 6. Enforcement and penalties. Sanctions, financial penalties, proportional to offense severity. Restitution, orders to compensate affected investors. Suspensions, of licenses, listings, or trading activities. Offenses, non-compliance with investigations, false disclosures, or unauthorized SRO operation are criminal offenses. Conclusion. Part 2 establishes the CMA as Kenya's apex capital markets regulator, balancing market development with investor protection. Its structure ensures expertise-driven governance, while its powers, licensing, investigations, AML enforcement, and tools, compensation funds, SRO collaboration, foster a transparent, efficient, and fair market. The Act emphasizes public participation in rule-making, cross-border cooperation, and adherence to data privacy, aligning Kenya's markets with global standards. Summary of Part 3 of Kenya's Capital Markets Act, CAP, 485A, Provisions relating to exchanges. 1. Approval and licensing of exchanges. Requirement for approval. No person or entity can operate a securities exchange, commodities exchange, or derivatives exchange without approval from the Capital Markets Authority, CMA. Unauthorized use of terms like stock exchange, securities exchange, or derivatives exchange is prohibited. Application process. Applicants must submit a formal application to the CMA, accompanied by a fee. The CMA approves applicants if they meet specific criteria, including being a limited liability company, having a board of directors constituted as prescribed by the CMA, adopting rules compliant with the Act and CMA regulations. Ongoing compliance. Approved exchanges must pay an annual fee and comply with CMA requirements. Exchanges may also need to register as self-regulatory organizations, SRO, to maintain their licenses. 2. Rules and governance of exchanges. Rule-making authority. Exchanges can create rules to regulate their activities, products, systems, and fees. These rules must be submitted to the CMA for review at least 30 days before implementation. Amendments to rules. Exchanges cannot amend, vary, or rescind their rules without prior CMA approval. The CMA has 30 days to review proposed changes and may approve or reject them, providing reasons for rejection. Emergency rule changes. Certain rule changes, for example, fee adjustments, administrative matters, can take effect immediately upon filing with the CMA, but the CMA can later revoke them if necessary. 3. Disciplinary actions by exchanges. Disciplinary powers. Exchanges can reprimand, fine, suspend, or expel trading participants, for example, brokers or listed companies for rule violations. The exchange must notify the CMA of any disciplinary action within 7 days. CMA oversight. The CMA can review and override exchange decisions, either on its own initiative or in response to an appeal by the affected party. If an exchange fails to act, the CMA can directly discipline the offending party after giving them a chance to be heard. 4. CMA's direct intervention in exchange operations. General directions. The CMA can issue written directions to exchanges to ensure fair, transparent, and efficient market operations, proper clearing and settlement of transactions, integrity and management of systemic risks, protection of investor interests. Emergency powers. In cases of market manipulation, major disturbances, or threats to public interest, the CMA can suspend or terminate trading, limit trading to liquidation of positions, modify trading hours, delivery conditions, or settlement prices, impose margin requirements or modify exchange rules. Trading suspensions can last up to 3 months, with a possible extension of another 3 months. 5. Regulation of derivatives exchanges. Approval of derivatives contracts. Derivatives exchanges must obtain CMA approval before listing any exchange-traded derivatives contracts. The CMA can impose conditions or restrictions on trading and withdraw approval if the exchange violates these conditions or if trading poses risks to investors. Position and trading limits. The CMA can set limits on the number of contracts a person can trade or hold to prevent excessive speculation. These limits apply to individuals or groups acting in concert. 6. Clearing houses and insolvency. Default process. The default process of a clearinghouse, for example, handling failed trades, takes precedence over insolvency laws, ensuring orderly resolution of defaults. Key takeaways. Part 3 of the Act ensures that stock exchanges, commodities exchanges, and derivatives exchanges operate in a fair, transparent, and efficient manner. Here's what it means in simple terms. 1. Licensing and rules. Exchanges must be approved by the CMA and follow strict rules. They can't just call themselves a stock exchange without permission. 2. Investor protection. Exchanges can punish brokers or companies that break the rules, but the CMA has the final say and can step in if needed. 3. Market stability. The CMA can intervene during emergencies, for example, market crashes or manipulation, to protect investors and restore order. 4. Derivatives trading. Trading in complex financial products like futures and options is tightly regulated to prevent excessive speculation and protect the public. 5. Clearing houses. If a trade fails, the clearing house's process for resolving the issue comes before other legal claims, ensuring markets remain stable. Why this matters. These provisions ensure that Kenya's financial markets are well-regulated, transparent, and investor-friendly. By setting clear rules and granting the CMA oversight powers, the Act helps prevent fraud, manipulation, and systemic risks, fostering trust and confidence in the markets. Summary of Part 4 of Kenya's Capital Markets Act, CAP, 485A. Securities Industry Licenses and Public Offers of Securities. 1. Licensing requirements for market participants. Who needs a license? Anyone operating as a stockbroker, dealer, investment advisor, fund manager, rate manager, commodity broker, online forex broker, or similar roles must obtain a license from the Capital Markets Authority, CMA. Exchanges, for example, securities, commodities, derivatives, and collective investment schemes, for example, mutual funds, must also be approved by the CMA. Application process. Applicants must submit a formal application, pay a fee, and provide additional information if requested by the CMA. Licenses are granted based on financial stability, qualifications, and reputation of the applicant. The CMA can impose conditions on licenses and modify them as needed. Key personnel changes. Licensed entities must notify the CMA before changing shareholders, directors, or key personnel. 2. Suitability criteria for licensing. The CMA evaluates applicants based on financial status and solvency, qualifications and experience of the applicant and key personnel, reputation, character, and integrity of the applicant and its associates, compliance history with financial regulations. The CMA can reject an application if the applicant is deemed unfit, for example, due to past fraud, malpractice, or incompetence. 3. Sanctions and penalties for breaches. Types of sanctions: public reprimands, trading suspensions, license restrictions, or revocation. Financial penalties, up to 10 million Kenya shillings for entities, 5 million Kenya shillings for individuals. Recovery of ill-gotten gains, double the benefit obtained from the breach. Restitution orders. The CMA can order compensation for investors who suffer losses due to breaches. Disciplinary actions. Employees or directors involved in misconduct can be disqualified from working in the industry or face personal fines. 4. Suspension or revocation of licenses. Grounds for suspension or revocation: insolvency, misconduct, failure to comply with license conditions, or providing false information. Licenses can be suspended for up to 3 months with a possible extension of another 3 months. Effect of revocation: existing agreements, for example, client contracts, remain valid, but the CMA can require the transfer of client records or allow the entity to wind down operations. 5. Register of license holders. The CMA maintains a public register of licensed entities, updated annually and whenever a license is suspended or revoked. 6. Licensing requirements for specific roles. Stockbrokers must act solely on behalf of clients. Dealers can trade on their own behalf. Derivatives brokers can trade on behalf of clients or themselves. Ownership limits: no individual or entity can control more than 3% of a licensed company's shares, board appointments, or dividends. 7. Collective investment schemes, SIS. Registration requirement: all SIS, for example, mutual funds, unit trusts, must be registered with the CMA. Application process: promoters must submit incorporation documents, proof of lawful constitution, and an application fee. Public offers: registered CIS must publish an information memorandum, similar to a prospectus, before offering shares to the public. 8. Public offers of securities. Definition: a public offer includes any invitation to the public to subscribe for or purchase securities. Prospectus requirement: issuers must submit a prospectus to the CMA for approval before making a public offer. Exemptions: certain offers, for example, to sophisticated investors, may use a short-form prospectus or be exempted entirely. Criminal liability: issuers, directors, and advisors can be held liable for false or misleading statements in a prospectus, with penalties including fines, up to 30 million Kenya shillings for companies, and imprisonment, up to 7 years for individuals. Compensation for investors. Investors who suffer losses due to false or misleading prospectuses can claim compensation from issuers, directors, and advisors. 9. Disclosure obligations. Ongoing disclosure. Issuers must promptly disclose any information that could affect their financial position or the market price of their securities. CMA directions. The CMA can issue directions to issuers to cease breaches, correct disclosures, or take other necessary actions. 10. Asset-backed securities ABS. Definition: ABS are securities backed by assets, for example, loans, receivables that generate cash flow. Regulation: issuers, originators, and trustees must comply with strict rules on asset transfers, disclosure, and due diligence. ABS must be issued under a prospectus or offering memorandum approved by the CMA. Trustee role: trustees oversee the securitization process, ensuring compliance with the trust deed and protecting investor interests. Rating requirements: ABS must be rated by a credit rating agency, and issuers must maintain the rating throughout the security's life. Key takeaways. Part 4 of the Act ensures that market participants, for example, brokers, advisors, fund managers, and issuers of securities operate in a transparent, accountable, and investor-friendly manner. Here's what it means in simple terms. 1. Licensing. Anyone offering financial services or trading securities must be licensed by the CMA. Licenses are granted based on financial stability, qualifications, and integrity. 2. Investor protection. Issuers must provide accurate and complete information in prospectuses. Investors can claim compensation for losses caused by false or misleading information. 3. Market integrity. The CMA can impose fines, suspend licenses, or revoke them for misconduct. Ongoing disclosure requirements ensure transparency in the market. 4. Complex products, for example, ABS. Strict rules govern the issuance of asset-backed securities to protect investors. Trustees and credit rating agencies play key roles in ensuring compliance. Why this matters? These provisions create a safe and fair environment for investors by ensuring that market participants are qualified, transparent, and accountable. By regulating public offers and complex financial products, the Act helps prevent fraud, promotes market stability, and builds public trust in Kenya's capital markets. Summary of Part 5 of Kenya's Capital Markets Act, CAP, 485A, Securities Transactions and Registers. This section outlines rules and regulations governing securities transactions, as well as the maintenance of registers for interests in securities. Transactions in securities. 1. Transfer of listed securities. A licensed person, broker, or dealer cannot transfer listed securities outside the securities exchange where they are authorized to trade unless the regulatory authority has specific rules allowing it. The authority grants permission on a case-by-case basis after payment of a prescribed fee. 1A. Exceptions for transferring securities outside the exchange. The authority may allow transfers outside the exchange if 1. The transaction is considered a private transaction as defined by the authority. 2. The security trades over-the-counter OC, provided the trade is reported according to the authority's rules. 3. It benefits the shareholders of the company involved, considering all relevant factors and prevailing conditions. 2. Compliance with rules. Licensed persons, brokers, or dealers must follow rules set by the authority regarding clearance, settlement, payment, transfer, or delivery of securities. Violating these rules is prohibited. 3. Margin account requirements. Transactions involving margin accounts must comply with requirements established by the authority. Any deviation is not allowed. 4. Customer consent for lending or borrowing securities. Brokers or dealers cannot lend or arrange for the lending of securities held for a customer without the customer's written consent. Similarly, borrowing or arranging to borrow using a customer's securities as collateral requires the customer's written consent. 5. Prohibition of manipulation and fraud. It is illegal to engage in any transaction that involves manipulation, deception, or fraudulent practices when buying or selling listed securities. 6. Trading procedures for public companies. Persons holding shares in public companies listed on approved securities exchanges can only sell or transfer those shares in accordance with the trading procedures adopted by the exchange. 7. General prohibitions against fraudulent practices. No one may use deceptive schemes or devices to defraud others in connection with securities, engage in acts or practices that constitute fraud or deceit, make false statements about material facts related to securities, fail to disclose material facts necessary to avoid misleading others. Violating these provisions constitutes an offense. Register of interest in securities. 1. Applicability. This section applies to persons licensed under the Act, for example, brokers, dealers, financial journalists who provide advice, analyses, or reports about securities for publication. 2. Definition of financial journalist. A financial journalist is someone who writes about securities for newspapers or periodicals, offering advice, analysis, or reports. 3. Scope of securities. The term securities refers specifically to those quoted on a securities exchange. 4. Maintenance of a register. Licensed persons and financial journalists must maintain a register detailing their interest in securities. Any changes in their interest must be recorded in the register within 7 days of acquisition or change. 5. Inspection of the register. The authority or its authorized representatives can request the production of the register for inspection. They may also make copies or extracts from the register. Key takeaways. 1. Regulated transactions. All transactions involving listed securities must comply with rules set by the regulatory authority. 2. Transparency. Private transactions, OTC trades, and shareholder interests are closely monitored to ensure fairness. 3. Customer protection. Brokers and dealers need explicit customer consent before lending or borrowing securities on their behalf. 4. Fraud prevention. Strict prohibitions exist against fraudulent activities, including manipulative practices and false statements. 5. Disclosure requirements. Licensed individuals and financial journalists must maintain and update registers of their securities interests for transparency and accountability. These regulations aim to promote fair, transparent, and secure securities markets while protecting investors and maintaining public trust. Summary of Part 6 of Kenya's Capital Markets Act, Cap. 485A. Insider trading and other market abuses. This section outlines laws and penalties related to insider trading, market manipulation, and other unethical practices in securities trading. Application. These rules apply to listed securities, their derivatives, and derivatives traded on markets regulated by the authority. Key terms. Price-affected securities. Securities whose prices are likely to be materially affected if certain information becomes public. Inside information. Non-public information that could significantly impact the price of securities if disclosed. Insider. A person who possesses inside information. Insider trading. What is insider trading? An individual commits insider trading if they trade in securities or derivatives based on non-public information, inside information. Encourage others to trade using such information. Disclose inside information outside the scope of their professional duties. Actions considered dealing, selling, purchasing, exchanging, or subscribing for securities or derivatives. Acquiring or disposing of rights to sell, purchase, or subscribe for securities or derivatives. Inside information. Inside information is specific to particular securities or their issuers, not yet made public, likely to have a significant impact on the price of securities if disclosed. Information made public. Information is considered public if it is published according to securities exchange rules. It is contained in public records. It can be easily accessed by those likely to trade in the securities. Even if information is shared with a specific group, communicated for a fee, or published outside Kenya, it may still be treated as public. Penalties for insider trading. First offense. Individuals, fine up to 2.5 million Kenya shillings or imprisonment for 2 years plus repayment of gains or losses avoided. Companies, fine up to 5 million Kenya shillings plus repayment of gains or losses avoided. Subsequent offenses. Individuals, fine up to 5 million Kenya shillings or imprisonment for 7 years, plus double the gains or losses avoided. Companies, fine up to 10 million Kenya shillings, plus double the gains or losses avoided. Market manipulation. What is market manipulation? Engaging in transactions that increase or decrease prices to influence others to buy or sell securities. Stabilize prices to mislead others into trading. This includes exchange-traded derivatives and options on futures contracts. False trading and market rigging. Creating a false impression of active trading or misleading the market about security prices is illegal. Examples include entering into transactions without changing ownership, offering to sell securities at the same price as an offer to buy them. Fraudulently inducing trading. It is illegal to induce others to trade securities by making false, misleading, or deceptive statements, concealing material facts, recording or storing false information. Use of manipulative devices. Using schemes, devices, or practices to defraud others in securities transactions is prohibited. This includes making false statements or omitting material facts that make statements misleading. False or misleading statements. Making false or misleading statements to induce others to trade securities is an offense. This applies even if the falsehood arises from omitting key facts. Front running. What is front running? A market intermediary using inside knowledge of client orders to execute personal trades before the client's order is executed, taking advantage of price differentials. Facilitating this practice is also an offense. Liability to pay damages. Persons convicted of offenses under this part must compensate anyone who suffers financial loss due to their actions. This does not limit other civil liabilities they may face under different laws. Obtaining gain by fraud. Using deceit, concealment, omission, or fraudulent means to gain financial or personal benefits from the public, issuers, or regulated entities is an offense. Penalties for insider trading and market abuse. General penalties. Individuals. Fine up to 5 million Kenya shillings or imprisonment for 2 years plus double the gains or losses avoided. Companies. Fine up to 10 million Kenya shillings plus double the gains or losses avoided. Key takeaways. 1. Insider trading prohibition. Trading based on non-public price-sensitive information is strictly forbidden. 2. Market integrity. Practices like market manipulation, false trading, and front running are illegal to ensure fair markets. 3. Transparency. Information must be made public in ways that allow all investors equal access. 4. Penalties. Significant fines and imprisonment are imposed for violations to deter misconduct. 5. Compensation. Victims of these offenses can seek damages for financial losses caused by unethical behavior. These regulations aim to maintain fairness, transparency, and trust in the securities market while protecting investors from fraud and abuse. Summary of Part 7 of Kenya's Capital Markets Act, Cap. 485A, Miscellaneous Provisions. This section outlines various rules and regulations that govern the management, oversight, and enforcement of securities-related activities. Powers of the authority to intervene in management. When can the authority intervene? If a licensed person's license is suspended, if there is a proposal to wind up a licensed entity, or if a receiver is appointed, if the authority discovers issues that threaten investors' interests. What can the authority do? Appoint a statutory manager to take control of the business, excluding the board of directors. Remove officers or employees who have caused harm or acted against investor interests. Appoint a new director with the authority's approval. Cancel powers of attorney or other authorities held by the licensed person. Statutory manager's role: manage the business for up to 12 months, extendable by the High Court. Preserve assets, recover debts, evaluate financial health, and recommend restructuring. Operate under a moratorium on payments to creditors during their term. Appeals and liabilities. Removed employees can appeal to the Capital Markets Tribunal. The authority and its appointees are not liable for actions done in good faith. Winding up. If necessary, the statutory manager can petition the court to wind up the company. Reporting prohibited conduct. Anyone providing services to a licensed person or a listed company must report any prohibited conduct to the authority. Failure to report is an offense. Remedy for unfair prejudice. If a listed company or special purpose vehicle acts unfairly toward its members or investors, the authority can apply to the court for remedies such as restraining orders, appointing managers, or requiring share purchases. For securitization transactions, the court can change trustees or receivers to protect investor interests. Demanding production of records. The authority can demand records and documents from companies, subsidiaries, or entities involved in securities transactions if it suspects fraudulent or prejudicial behavior. This includes copying documents, demanding explanations, or investigating misconduct. Banks can only provide copies or extracts of records. Winding up. If necessary for investor protection, the authority can petition for the winding up of a licensed person under the Companies Act. Other offenses. Offenses include violating provisions of this act, providing false or misleading information, obstructing authority officials in their duties. Penalties vary depending on the nature of the offense. Offenses and penalties. First offense. Individuals, fine up to 5 million Kenya shillings or imprisonment for 2 years plus double the gains made or losses avoided. Companies, fine up to 10 million Kenya shillings plus double the gains made or losses avoided. Subsequent offenses. Individuals, fine up to 10 million Kenya shillings or imprisonment for 5 years plus triple the gains made or losses avoided. Companies, fine up to 30 million Kenya shillings plus triple the gains made or losses avoided. Compensation may also be awarded to affected parties. Compounding of offenses. The authority can settle minor offenses by accepting payment instead of pursuing prosecution. Payment must be made within 14 days to avoid further legal action. Funds collected go into the Investor Compensation Fund. Appeals from authority actions. Persons aggrieved by decisions of the authority, for example, refusal of licenses, restrictions, suspensions, can appeal to the Capital Markets Tribunal within 15 days. The tribunal has powers similar to the High Court, including summoning witnesses and ordering compensation. Establishment of the Capital Markets Tribunal. Composition includes legal experts, accountants, and professionals experienced in securities. Members serve for 3 years and can be removed for misconduct or inability to perform duties. Powers hear appeals against authority decisions, make awards, order costs, and enforce rulings. Procedure. Hearings are open to the public unless confidentiality is required. Decisions must be made within 90 days. Appeals on points of law can be taken to the High Court. Directions and submission of reports. The Cabinet Secretary can request reports from the authority about its operations and finances. The authority must submit annual reports to the Cabinet Secretary, which are then tabled in Parliament. Exemption for existing securities exchanges. Existing securities exchanges approved before the enactment of this section can operate as derivatives exchanges for up to 3 years, provided they meet certain requirements. For example, minimum capital risk management systems. After 3 years, they must comply fully with derivative exchange regulations. Supersession. In case of conflict between this Act and other laws, this Act takes precedence regarding the authority's powers and functions. Prosecution of offenses. The Director of Public Prosecutions can appoint authority officers or advocates to prosecute offenses under this Act. Exemption from State Corporations Act. The authority is exempt from the provisions of the State Corporations Act. Key takeaways for Part 7 as a whole. 1. Regulatory oversight. The authority has broad powers to intervene in cases of misconduct, unfair practices, or threats to investor interests. This includes appointing statutory managers, removing personnel, and even petitioning for the winding up of a company. 2. Transparency and accountability. Entities must produce records when requested, report prohibited conduct, and face penalties for non-compliance. This ensures transparency in operations. 3. Protection for investors. Remedies like compensation, restructuring, or winding up are available to address unfair treatment of investors. The Act prioritizes investor protection. 4. Appeals process. A fair appeals mechanism exists through the Capital Markets Tribunal, providing a recourse for those aggrieved by the authority's decisions. 5. Penalties for misconduct. Significant fines and imprisonment await those who violate securities laws, serving as a deterrent. Penalties are cumulative, meaning they include both fines or imprisonment and repayment of gains or losses. 6. Exemptions and transitions. Existing exchanges have temporary exemptions but must eventually comply with stricter standards, indicating a move towards greater regulatory consistency. 7. Supremacy of the Act. The Capital Markets Act takes precedence over other laws in matters relating to the authority's powers, ensuring clear regulatory authority. 8. Compounding of offenses. The authority has the power to settle for payment for minor offenses. These provisions, taken together, aim to create a robust regulatory framework that ensures fairness, transparency, and accountability in Kenya's capital markets, ultimately protecting investors and maintaining public trust in the financial system.